Good afternoon, everyone. I am Wilda Pomales, the family law attorney here at the Legacy Legal Team. Today we will be discussing mediation, and I am a family law attorney, but today I will be wearing the hat and going over mediation from, sorry, my camera here was quickly fell. Let me just adjust this. We will be talking about mediation from the certified mediator perspective. While I am a family law attorney, I am also a certified mediator, family mediator. And so when I am mediating, I am not advising or representing a client. I am a neutral party in the process. And so today we will be going over that and what is the difference, right? Every mediation that takes place in the family realm is voluntary and it's confidential. And so if you attend mediation for your family case, whether it's a divorce, paternity case, a modification, anytime you file a family matter with the courts, you have to attend mediation prior to going into the final hearing or trial. You will have to attend mediation. And so if you're trying to modify your case, maybe a final judgment was entered in the past for your divorce or for your paternity case, and you're trying to modify something, whether it's the time sharing or child support, then you're going to have to attend mediation again. And so what does mediation look like? Again, sorry for my camera. It is not wanting to stay put. Let me try adjusting it again. Okay, so when you attend mediation, again, I'm a neutral party, and so if you hire me to mediate for you, I'm not able to give you any legal advice, so I do not tell either party which way or what terms to decide on. I am there to facilitate the process for you guys, for both parties, and draft any agreement that may be entered into at that time and during that session. And so mediation can be anywhere from 3 hours, whatever you need, to a full day to try to draft those agreements that you guys need to submit to the courts, whether it's time sharing, child support, whatever it may be. And so let's just go from let's say a divorce. If you're filing a petition for dissolution of marriage, you're going to have to go through the mediation process. You can schedule a date with us, give our firm a call, see what your availability is. Both parties need to attend, of course. It could be done virtually, it could be done in person. And so once you start that session, again, it's confidential. So I can never be pulled into the courts to testify as to what was said at the mediation. So sometimes the parties can say, okay, maybe we can agree to this. They leave without signing any documents, and then later on change their mind, change their perspectives on things, and don't want to agree to whatever the terms are. And so if that happens, I cannot be called back into court or into any type of hearing to let the judge know what was said originally at the mediation. It is confidential. And voluntary is you guys are required to be there by the courts, but you're not required to stay for the full session. Let's say we are scheduled to meet for 2 hours. You're not required to stay there for the entire 2 hours. You can, as soon as I say my opening and explain what the process is, you can discuss anywhere from 5 minutes to an hour, whatever time you want. If at any time the parties want to end the sessions, either party can state they want to end it, and all that will be reported to the courts will be that the parties attended mediation. There was an impasse, so no agreement was made, or whether there was an agreement or not. But if there is no agreement, then the court will not know, okay, respondent was the one that did not want to negotiate or was not willing to stay, or petitioner was the one that decided to end the mediation. There will be no report to let the court know which party ended the mediation process. A lot of times the questions that are asked are, will the parties need to be represented by counsel at mediation? It is not required. Again, this is a process that can be done just by the parties themselves representing themselves. So in a self-represented matter, or you can be represented. And again, because although I'm an attorney, a family law attorney, I am a neutral in the mediation process. And so at that time, you can schedule a mediation session with me and bring your attorney with you. Each party can be represented by their attorney. We always recommend that an attorney review the documents, whatever agreements are made, and we do recommend that you do consult with your own attorney, again, because I'm not able to represent any parties at that time. And so at that time, you would be able to consult with your attorney and ask, okay, is this agreement okay? What terms should be negotiated? What terms can be continued to be renegotiated or whatever? But that is all happening before you actually file or before you actually sign the agreement. Once you sign the agreement, that agreement is submitted to the courts. As a mediator, I submit the agreements to the court, file it with the courts, and let the court know that partial agreement was made, no agreement was made, or a full agreement was made. And before signing, you can request that a copy of the agreement, take it to your attorney if you're going to hire an attorney, and have them review it before you sign it. And that is if you're self-represented and seek representation afterwards. Sometimes the parties have discussed the terms and know exactly how they want to divide their assets and liabilities, if it's part of a divorce or the time sharing. And so they don't need representation, and they just want the documents or the agreements to be completed and drafted correctly. And so they'll come to us as self-represented litigants and just mediate and have me draft the agreements for them to be able to sign and submit to the court on their behalf. Now, mediation, if you're not represented by an attorney, mediation gives you the agreements as far as divisions of assets and liabilities or a parenting plan, but it will not give you all the documents and all the pleadings that are needed for your matter. And so do not get confused in thinking that, okay, if we attend mediation and we're not represented by an attorney, the mediator will draft all the documents that we need to file to start and end our case. That is not the case. So you will still need to file a petition, whether it's a petition to determine paternity or a petition for dissolution of marriage, whatever your matter is, you will still need to file the initial documents for that matter. And that is by going to the courts, obtaining a packet for that type of case, filling it out and submitting it to the courts. So during the mediation process, you'll be able to, if you agree to the terms, any mediator, such as myself, can draft the agreements, but we're not in charge of drafting the pleadings and everything that goes along with starting and ending your case. So another option for why people use mediation is because it is less costly, right? You're not paying an attorney. You're splitting the costs. Most of the times the parties are splitting the costs of mediation equally. And so our hourly rate, however long we're taking in mediation, is equally split between the parties. So you guys are paying 50-50 for the hourly cost. And so that is also a way to save on expenses for the process. Again, you're not having to pay an attorney to draft that. And sometimes if one of the parties is being represented by an attorney, the other party is skeptical as to the agreements that are drafted. They believe it may be one-sided, and they are skeptical and do not sign as freely. Because again, the attorneys cannot represent two parties. The attorney is only bound to represent one party at a time, and so it makes it difficult for one party to be represented when the other one is not. And so really are both of their interests being taken into consideration. And so sometimes by coming to mediation, both of you are able to discuss freely and openly, and the mediator, again, being the neutral, is just drafting those agreements for you, right? They're not saying don't do that because this is what you're entitled to, or don't get into that agreement because this is how you would benefit if you go a different route, right? The mediator, as a neutral, is just there listening, and facilitating the process, and then just putting it down on a piece of paper so that way the court accepts it. Of course, it's done through as the statutes permit and allow. Child support can be ran and calculated at that time if it is something that needs to be done, if there are any minor children. So it's definitely a process that can save you time. Going through trial is a long process. If you guys reach an agreement at mediation, then it's something that you avoid trial and having to continue to litigate. And then again, you're saving in the cost of retaining attorneys for each of the parties because you guys are fully agreeing to whatever the terms are. Another thing is that after mediation, once the agreements are submitted to the courts, you may have to still schedule a final hearing. It may be a short matters. If there's a full agreement at mediation time, you can reach out to the courts and find out if you need a final hearing for your case, for your matter. And it might just be something quick, maybe 10 minutes long, where the judge confirms that the agreement has been submitted, everything is in order, and then the judge will sign off on your final judgment. So it is something that you still have to continue to follow up with the courts to make sure that the final documents are completed in your matter. Again, like I said, the mediation process can be done virtually or in person. The parties can come to our office, or we can do it through Zoom, Teams. Now with the process being allowed to be done virtually, we've had some cases where one of the parties is out of state, and so mediation has to be done virtually so that the parties can attend in a timely manner, and you don't have to be waiting for when the party is in town or in the States, to be in Florida, to be able to attend mediation in person. So definitely virtual is an option that you're able to do. Now, again, since I am a family law attorney, if I am representing a party for a family case, I cannot then conduct the mediation for the parties. If, let's say, for example, one of the parties, the other side, is not represented, I cannot be the mediator in that matter. I either have to be the mediator as neutral from the beginning, or I represent one side. So I am the attorney that represents one of the parties, but I cannot do both. I cannot go in between and be hired first as an attorney and then serve as the mediator in that case, even if one of the parties decides, okay, I will no longer want you to represent me. We have to do one or the other. So you would have to determine that with the other party ahead of time before retaining us for any of those services. Any other questions that may come up? Again, it's just the length of mediation, and that is up to the parties. Again, how many issues need to be resolved. The amount of time at mediation will depend on the parties. It could be done for 1 hour, a full day. It could be done for multiple days when there are multiple issues like divisions of property, and we need to be drafting the agreements because part of the mediation is drafting the agreement. So however long that takes, it could be multiple days, but we can break it up as needed. The parties sometimes come to mediation, they resolve certain issues and continue to litigate, and then return back to mediation once they're ready to resolve the remaining issues. So that is something that you can also do. Break it up into sessions. It doesn't have to be back to back or one day after the other. You can schedule something this month, come back next month, or a couple months out, whatever works into your schedule. So it's very flexible in that aspect. Still a lot quicker than waiting for the court to give you that final hearing or a trial date to finalize your matter. Again, it is confidential, so nothing that is discussed in mediation is ever brought back to court, or the mediators do not come and testify to state what it is that happened during mediation. And I think that is pretty much the gist of mediation. And at any time in your case, you can even attend mediation before you file a petition. If you're looking to get into an agreement prior to filing whatever the divorce or the paternity case or modification case, you can definitely attend mediation before That way you have your agreements and you file your petition along with your agreements at the same time. So you can definitely attend mediation before filing any type of petition or opening up any type of family matter in the courts. Again, feel free to give us a call, schedule a consultation. If you're not sure whether you need full representation or mediation, that can be discussed at the onset of the consultation so that I'm not conflicted out of representing or mediating for the parties. And so that is definitely options that we can discuss during the consultation process. Feel free again to give us a call, and if you have any further questions, we're available and can schedule time to discuss anything further. Thank you and take care.